Our second panel, Telecom Bill, Tech Innovation, Licensing and Privacy, is moderated by Tanveer Oberoi. Tanveer is a commercial and corporate disputes lawyer practicing in New Delhi. Joining him is Apar Gupta, a seasoned lawyer, activist, and writer who specializes in the intersection of technology and democratic rights in India. Vrinda Bhandari, lawyer at the Supreme Court of India, and Shreya Singhal, a practicing advocate based in New Delhi, whose petition struck down Section 66A of the IT Act, holding that Indians have the fundamental right to freedom of speech and expression on the internet. To ensure a healthy discussion, I kindly request everyone to switch off their cell phones.
Hello, good evening, everyone. I welcome you to the second panel in Digital Dialogues. Um, as we were just introduced, this panel is dealing with the Telecom Bill 2023, which was introduced in the Lok Sabha on the 18th of December as a finance bill. The Telecom Bill looks at repealing two colonial era laws, the Indian Telegraph Act of 1885 and the Indian Wireless Telegraphy Act of 1933, as well as the Telegraph Wires Unlawful Possession Act, which was passed just right after independence in 1950. Additionally, changes are being made and amendments are being sought to be made to the Telecom Regulatory Authority of India Act, the TRI Act of 1997, which looks at watering down provisions of that act and diluting certain powers of the regulatory authority. As the panel's already been introduced, we can jump right into it. Apar, why don't you start by going through certain, fundamental aspects of the bill and perhaps highlighting some of the notable areas of concern?
Hello, everyone. So the way I'm trying to model these initial comments is just to provide a frame for the conversation which is to follow. So here it's important for us to understand that the Telecom Bill is in a series of proposals and actual laws which have been passed which seek to govern and control how we transmit information. It includes the Post Office's bill, it includes the ID rules, it includes the Digital Data Protection Act, and it also includes the proposal which is presently in consultation called the Broadcasting Services Bill, right? Now, what is the common thread between all of these proposals has been one, the increase of certain chosen private firms which provide us these services, which is essentially the government picking what are called as national champions, right? Very large conglomerates. And the second is the growth of the government's own power over the lives of every ordinary Indian. These are the two common threads which run through it. And how does it justify this? I think it justifies this, and this is an authoritarian way to increase control by making recourse to what is a theological conception of what should be a government or a system run by scripture rather than constitution. And it comes across very clearly if you look at the consultation paper for the Telecom Bill, which stated in paragraph 3 that in a way spectrum is similar to Atma, which is Ajar Amar as described in Srimad Bhagavad Gita. Now you may laugh at it, okay? But there's actually a renaming of the Universal Service Obligation Fund to something else. You look at the three criminal laws, it is the same. Now, flowing from this, let me come to what are the main concerns which impact ordinary Indians. Here, there are four powers here, or four basic issues here with this law, which may be meriting further discussion. The first is with respect to surveillance and interception, okay? The second is with respect to internet shutdowns. The third is with respect to specifically encryption-based services, okay? And fourth are the positive duties or the kartavya kal provision, which is there in all laws now, in which you have to provide complete information. You can't resist any kind of demands for personal data by citing anonymity or a privacy interest, and there's a fine of 25,000 rupees which is placed on you. The third and the final part, which I think, so firstly, it emerges in a political economy in which there's a growth of corporate chosen firms which provide us these services and government control, right? What justifies it is a larger theological conception of the state. It directly impacts user rights, which are the four things I told you about. And finally, what is the political economy in which they are being passed, which is essentially that a majority of the opposition MPs are suspended, and even if they were not suspended, there would be no deliberation, for the overturn window has shifted so far past that this bill cannot even be referred to a standing committee of parliament for further study and deliberation. Thank you, Tanveer.
Thanks, Apar. So, since this session's title is Tech Innovation, Licensing, and Privacy, Vrinda, I'd like to come to you to just highlight some of the key aspects of the bill which deal with the licensing aspect, because when the bill was put out for public discourse in September 22, what struck most stakeholders was that the definition of telecommunication services included at that time over the top services, which is missing from the bill as introduced now. Perhaps you could touch upon that and look at some of the other definitions in the bill and how it affects how the bill is going to be read.
Yeah, so according to me, what the act has done is the earlier consultation used the word licensing, and there was a lot of hue and cry that, oh my God, you're going to license everything. So what they've smartly done is they've removed the word licensing, but they've kept the word authorization, which effectively means exactly the same thing. And it says, if you look at the definition of authorization, you need the permission by whatever name called for providing any telecommunication services or operating these telecommunication services. And this then goes into the problem of what is a telecommunication service. Now, the act currently is the bill, is so broadly defined that it includes any message, it includes, any content. Effectively, it doesn't even limit it. It doesn't say, for instance, if messaging is your primary, if messaging is the primary source of your social media app, right? So that's what you saw in the intermediary rules, where they say that if you're a messaging based app, so like WhatsApp would be covered. But technically here, Paytm would be covered, GPay would be covered. All of these services are covered. And then when you look at the fact that there is no threshold in terms of, are you a small player, are you a large player, everyone will require authorization from the government to enter. And then when you put this in context of the larger sort of political economy that Apar has talked about, that is when you are then concerned about who is the person who is going to be licensed, how are these licenses going to be introduced. And so, even on OTT, it's not directly there, but is it going to be introduced through some kind of backdoor mechanism? It's anyway already being regulated under the broadcasting bill. I mean, I think for me, what's interesting is there are all of these laws. There are now, we are seeing a conflation of powers in different laws. So for instance, you have the power here. Now they've given search and seizure powers here as well, which to me is very concerning. You already have a detailed search and seizure kind of, some sort of safeguards, minimal as they are, in the CRPC. Now, this doesn't say you have to refer to the code. So does it mean that the search and seizure power here is going to be independent of the CRPC? How are they all going to work together? You have internet shutdowns now being permitted here. You have them also being permitted under the telecom suspension services. Like, so is that going to go, because technically that's under the telegraph rules? You then also have a problem. So to me, what's interesting is you're regulating different things from different angles. So you're also allowing blocking powers, for instance, both in this, under the IT Act and under the Data Protection Act. So even the Data Protection Act has some provision of like, has these powers that are permitted in terms of blocking. So to me, what we see is that different laws are now, give this one part, but don't talk about how it relates to everything else. And then just very briefly, the two other sections that I wanted to touch upon, and we can discuss that more in question answers. So I've spoken about the licensing authorization, section 3, internet shutdowns. Also section 20 is something which I would like to discuss in more detail later on, because it allows the government effectively, it does not have any safeguards right now for interception. It allows you to also stop any class of messages from being broadcast. So tomorrow if the government says, oh, any messages on Manipur violence because they're inflaming tensions, they should be blocked. There is nothing, there is no safeguard in the law that prevents this. So the power is actually very broadly defined. And so to me, again, that's a matter of, a cause of concern. Search I've already spoken about. And then when the government is going to notify these encryption standards, there is not even that one line that, these standards should be notified keeping in mind privacy. Like you've spoken about, the importance of privacy. There is not even that basic guiding principle that's been given to the government to say that your encryption standard should meet with a certain privacy component. And so when we see all of the litigation that's been happening and all of the pressure that's being put to break end-to-end encryption, you wonder how is this law going to be, implemented. Some of you may remember, I think this is maybe 5-7 years ago, the draft encryption standards had come under the IT Act. And they were extremely, extremely onerous. It basically allowed the government to break encryption. So I think these are the different concerns. And what we're seeing is more and more powers are being just left to the government to delegate without any legislative principle that's encoded in the law.
Yeah, thanks, Vrinda. Before we move to Shreya to talk about the privacy angle, I just want to stick with Vrinda for a moment right now. So you touched upon how, the definition has been watered down to include messaging, and how if we look at beyond just the licensing aspect, there are other provisions which Apar, I'm sure, would like to talk about, which deal with, know your customer, KYC norms, biometrics having to be submitted. Um, would that include would that then mean that going forward now, if these messaging apps were to be brought under the ambit of this act, we'd all have to then submit our biometrics to analysis to be able to utilize these services?
Yeah, I mean, I think that's a very good question for everybody. Like that section 3(7) of the law sort of speaks about that, and I'll just read it out. Which says that any authorized entity which provides these telecommunication services, as will be notified by the government, shall identify the person to whom it provides these services through the use of verifiable biometric based authentication. When you talk about the entire Puttaswamy judgment, the Aadhaar Act, and even the Aadhaar judgment, as flawed as it was, talked about the idea of data minimization. We don't want private actors and the government collecting unnecessary data. You are effectively allowing the government and companies now to say all of you must have biometric authentication. And what is verifiable biometric authentication? I don't, for instance, on my iPhone, I've not enabled, face unlock because I don't want, I just don't trust the technology, so that's my own choice that I've made. So you are effectively killing any choice, any consent that any user has and saying that we need the data. So the presumption is that all of us are criminals. Like the presumption has changed from a presumption of innocence to a presumption of criminality, which is that collect data on anybody so that if we need something in the future, we will have it, rather than what is the current standard, which is that there is a crime, there is a suspect, you then can investigate them and seek, additional data. Here you're saying collect all this data, and I mean, I'm not even speaking about all the cyber risks, the security risks with this kind of data being there, being misused, being sold. So I think I think it's a huge problem.
Yeah, that's a great point, because it came up in the first session as well. That's one of the panelists was called in now, and his data was shown to him as screen grabs from 2014 was shown to him. So that's a valid point that, how much are they collecting? What are they collecting it for? How long are they retaining it? Under the Data Protection Act, as Aadhaar touched upon, they're meant to, specify the purpose for retention of such data. Yeah,
I mean, just on that, on like specifying the purpose, and sorry, like I really will stop.
please.
The whole problem with the data protection law is also that the government is actually exempt from complying with any of this. So this whole idea of purpose limitation, collection limitation, that you specify the purpose doesn't apply to the government if they choose that. So I mean, that's another problem.
So Shreya, just touching upon the privacy angle, Vrinda referred to the nine-judge judgment of the Supreme Court in Puttaswamy. In that, it was held that whilst privacy is a fundamental right under Article 21, it's not an absolute right. Referred to the Shreya Singhal judgment, which even held that even the freedom of speech and expression is subject to reasonable restrictions. Under the bill as it currently stands, what are the privacy limitations that citizens should fear?
So, even just as Vrinda said about search and seizure and the kind of information stored, which is biometric based, those are big concerns for privacy, considering now everything is linked to Aadhaar. So you have got my PAN card linked to Aadhaar, you've got my phone linked to Aadhaar, you're giving out my Aadhaar information for everything. Where does it stop? What about my own right? Forget digital privacy, but my right that my fingerprint, my retinal scan, my face recognition is my own. These simple questions are just raised, they're put up. We've already had multiple breaches of Aadhaar information, which have gone. I don't know what kind of rectification has happened thereafter on this information that you are storing, and for what reason. It's, as Brinda rightly said, you're making everyone a suspect to collect all of this information. You might as well ask us for blood samples by the end of it. If there's a murder, you just put it through your national database of DNA to identify who has committed the murder. So rather than saying innocent until proven guilty, you're guilty until proven innocent, which is anyway what is happening today in the larger political landscape, and what, with the judicial process going so slow, unfortunately, that it is the presumption has switched completely, and the onus is on the person to prove their innocence rather than the state to prove the opposite. So coming back to specifically the Telecommunications Bill, everything in the name of national security and breaching that, literally cutting through every constitutional, fundamental, basic structure principle in the name of national security, an overarching umbrella term which can be used from anything to say that we anticipate there may be, because of the upcoming elections in, say, uh, even if it is a religion based population difference, different population, and saying that, oh, we're going to suspend internet services. What does this bill do? It goes one step further if it comes in. That is, that we'll cut all communications, because 20 section 20 subclause 2 says, gives the government the power, or the state, or a babu appointed by the government, to suspend all telecommunication services. That means, apart from, say, maybe the police and ambulance and emergency services like that, which means that you're not going to have an internet shutdown in Manipur. You will have a complete ban of all communications. Your mobile services will be suspended. You can't make a phone call to your friend. You can't make a phone call to your family. You can't check if your daughter or your son are okay. None of that. So that is very worrying.
Yes, it is. You said national security is an overarching term. So is, for the last several years, the term that's been doing the rounds, anti-national elements. Um, Apart, coming back to specific provisions, since you've been at the forefront through IFF, on the internet shutdowns. Anuradha Bhasin was a landmark judgment where dealing with the shutdown of suspension of internet services in J&K. Under the provisions of the Telegraph Act as it existed, there were provisions for taking over temporary possession. There were provisions for stoppages of subject matter transmission. There were provisions for interception of messages through telegraph means. Now, what's been expanded under the current bill?
So, firstly, I don't think so. I was at the forefront. It was actually a coalition. It included many lawyers. Anuradha Bhasin actually was a bunch of petitions, and it was actually a series of litigations, and a lot of lawyers and activists have been associated with it over time. Internet
It's a team
shutdowns impact people who suffer them in the states where they are most directly resident, and long periods of internet shutdowns have caused grave amounts of economic and social injury to people in Jammu and Kashmir and Manipur, almost reducing them to a barbaric sort of existence during COVID. So that's important to understand. Now, what does this bill do? This bill essentially ignores all the judicial precedent, which indicates a need for safeguard, or even the report of the Parliamentary Standing Committee on IT, which in fact one of the, and here I think so, given the partisan nature of standing committees, I think I can state it, was being prevented by the BJP MP Nishikant Dubey from actually finalizing the report on internet shutdowns, was stating it's of a political character. But that report, in fact, when it was made, if you look at the reports, they essentially need to be implemented by the department, okay? It includes the Department of Telecom. And what did the report say? It asked for a study to be conducted, okay, whether your internet shutdowns are actually able to satisfy the purpose for which they are made, which is essentially to restore law and order, and what is the impact on the person who suffers it, okay? The Department of Telecom refused to do it. The Department of Telecom refuses to make a centralized repository in which internet shutdown orders are sent to it by the state, by citing a specious argument of jurisdiction, whereas the National Crime Records Bureau publishes federal data on crimes which do occur. So all of this is a specious argument because it is resisting transparency again and again. And here I think what's important for us to also understand is one of the core policy issues in telecom is not being considered. The core telecom policy issue today is the flatlining of the user growth of the number of Indians who have access to internet. Now, this was growing at a double-digit growth in certain periods of time, which is then went to about 3 to 4%, and over the past 2 years is not increasing beyond 2%. There's saturation which is reached in urban metropolitan areas such as Delhi, where there are 2.4 to 2.6 connections per person. But usually this is in fact higher, because for a person like me, I have a cell phone, I have an iPad, and I have a connected car. I have 3 connections, and many people also have a wired connection, so they have 4 or 5, right? But what happens to the service provider in these cities? Let's say your maid, your driver, or anybody lower on a socio-economic zone, they have one connection which they share amongst their family. In fact, this is being shown through co-viewing data of YouTube, where in local chopals, 4 people are watching the same video through one smartphone. Co-viewing is a urban phenomena or OTT streaming. What all of this means is that the central challenge of digital divide, which needs to be addressed through telecom policy, and policy essentially is reflected through laws, is not being debated. Instead, what are we debating as internet shutdowns, increase in powers of the government to demand decryption of any kind of messaging services. We are also dealing with the entire dhacha which is just being taken over. So Tanveer, section 60, if you look at it, of this draft bill says that all the old rules which have been made under the Telegraph Act continue, which means Rule 419A, interception, which means suspension of telecom services rules. If you look at the language of section 5.2 of Telegraph Act and you then contrast it with the language for interception, etc., under this law, it's been made worse. I looked at it. The interception power under this law says that the message needs to be made in an intelligible format, which is not there in section 5.2. What that means is that if there's an interception order and it's a WhatsApp message given to WhatsApp, WhatsApp needs to decrypt it and give it to the law enforcement official. And how will it do it if it's implementing end-to-end encryption? Right? But this is where we are. Okay? And this is the law. But the question which again I think needs to be asked when we discuss the Telecom Bill, again and again, to Minister Vaishnav is, where are the growing number of internet users in India? And does this law fix it?
Yeah, that's a very valid point. I mean, the 2018 National Communication Policy of the Department of Telecom had laid down various benchmarks and had put 2022 as the year of, to come back and review. And they've missed all of those. Sure, they'll take the excuse of COVID, but that's a very valid point you've raised. If we just stick with the shutdown angle for a second, in Anuradha Bhasin, it had said that, the restrictions must be on the basis of whether they're legitimate, whether they're necessary, whether they're proportionate, whether alternative measures are available, and if so, the least restrictive measure should be taken. Now, you rightly said that the existing rules are to remain in force, and in that judgment, they said that the rules, the suspension rules of 2017, provide for certain checks and balances.
Yes.
Now, that being the case, if such rules were to continue to apply and this law was to become statute, how then would we be able to argue that those checks and balances are not sufficient?
Those checks and balances are not sufficient because the architecture of the safeguards internalizes the checks and safeguards to be implemented by the same authorities which pass the orders. It's essentially the same person who's conducting the exam, scoring the papers, as well as setting the paper, and is the student. Okay? And that is the government. Okay? It is the executive branch of the government. And just because you're placing faith that when you go from a junior officer to a senior officer, and if you put 4 senior officers together and you make a committee, things magically improve. It is, well, magic thinking, right? So going against experience, going against all that we have seen, and partly this is to blame from the Supreme Court itself, because this architecture comes from the PUCL telephone tapping judgment, okay, which then goes into Rule 419A, which then becomes the model for any kind of interception in which there's an authorized officer, there's a review committee, reasons need to be recorded in writing, reasons will not be made public, things need to be specified as per time, but then again, subsequent orders can be issued again and again. Or it goes back to courts when the courts say that even if an order for interception was not there and a person was prosecuted pursuant to evidence which was illegally gathered, that evidence is still admissible. In fact, Vrinda has written an excellent law review article on that. That there is no doctrine of fruit of the poison tree. What is your remedy in case you have been surveilled and there was no actual order for surveillance? Is to actually file a complaint against that police officer and for a departmental inquiry against that police officer to be held. So the architecture or safeguards itself, which also apply from interception to, let's say, suspension of the internet, which are called internet shutdowns, remains the same. It's faulty, it internalizes everything within the union executive, and there are no sanctions which follow.
Yeah, yes, please. Yes, please.
So, like, even specifically, one, the idea is if currently the legislative policy is bad, but may not be illegal. So they've said that the telecom suspension rules, they've not been held to be illegal. The hope is always, obviously, if you're coming out with a new law, you would want the policy to improve. You wouldn't want it to just replicate the existing provisions. So that's just a general point. And specifically on some of the problems in the current shutdown regime as well. One, unlike even the minimal safeguard that's there under the interception rules, the review committee, so that's the committee that Apar was talking about, doesn't actually have the power to to effectively stop the order.
So if I can, sorry to interrupt. If I can just ask a question, because this is going to be my next question to you, and I just want you to add a little bit more to it. So these rules are almost the same as the 2009 interception rules under the IT Act, the 2017 suspension rules, which the courts have held that the suspension order or interception order has to be, the authority for that order has to come from the Secretary of the Ministry of Home Affairs, and only then can that order be implemented. So according to the judicial pronouncements, that is a sufficient check and balance. So keeping that in mind, could you...
So the sufficient check, according to them, is not that the authority is the government, it's that there is a 3-member review committee, which is this executive committee, which consists of the Chief Secretary, the Secretary of Law, and the Secretary of MIT, Electronics and Information Technology. And that committee is going to review the order, and it's supposed to review the order every 15 days.
After 3 months, yeah.
Yeah, it's supposed to go. Now, the problem is twofold. One, these are as high-level bureaucrats. They're checking the one RTI that is available in the public domain, I think said 7,500 to 9,000 orders of interception were passed in 2009. We have no data since then. IFF has filed again and again. We have tried to get this data. Apar has filed that petition. We have...
My only case is to get aggregate data on surveillance orders.
We have been extremely unsuccessful. One reason or the other, we're still before the High Court. The matter has not been decided. And all we keep on trying to tell everybody and the judges is, we just want aggregate data. We are not asking for sensitive information. So we don't even have any updated information, but take 2009 data, which is 9,000 orders per month, central government. That means every 2 months, which is when the review committee meets, they have 18,000 orders. There is no way there is any application of mind that is happening here. So just from a practical policy perspective, and that one of the things that I had written in this article was that after Puttaswamy, I believe that the law should change and you would require some kind of judicial review. It's not enough to just have executive review. So that was one point. The second point I just wanted to point out is that you actually don't have very many orders of courts quashing internet shutdown orders for 2 reasons. One, on a practical basis, many of these orders are issued for 1 day or 2 days. So by the time you go to court, you coordinate with the petitioners wherever they are. It's very difficult to coordinate given lack of internet. And you go to court, they're like, oh, it's infructuous now. Anyway, internet is restored. It's going to get restored in 1 day. So what's the point? I'm not going to discuss this issue. It's a controversial political issue. So let's not get into it. It's become an academic issue. So A, it's hard to get an order. In Jammu and Kashmir, when we actually had all of those orders, the court, in all the petitions that we had filed, so we had moved, whether it was Anuradha Bhasin and then all the subsequent petitions that Apar had mentioned, where we specifically challenged the 2G restrictions during COVID, there's actually never been any finding on the merits of any order. The court has not looked at the merits of this order and said, look, does this meet the requirements of the law? So that's the other problem, that you actually don't have an application like a Supreme Court judgment which is applying the law to the facts of the case. And the third problem is just is that these orders are very short, so that I've already mentioned. So they become infructuous. So it's also difficult to get any judicial victory. So that also then results in a cycle where the government feels more and more emboldened. And it's not. I mean, honestly, shutdowns are a favored tool of every political party. I mean, Rajasthan is the state with the largest number of shutdown orders, like in the country. So it has, and these shutdown orders are for cheating, like to prevent cheating in exams, etc. So it's about what you regularize over time and where the Overton window sort of changes.
Thanks. Before we move to Shreya to discuss, the surveillance and privacy balancing act, Vrinda, I want to just stick with you for a moment because Apar had spoken about, encryption and the standards required. Now, if the government were to say instruct WhatsApp to release certain chats, which we as the public have been led to believe are end-to-end encrypted, and the disclaimer given by these apps is that even they can't view the messages. How does that work? In case they were to get instructions from the government that we need such and such chats.
I mean, that is the fundamental problem. Like, this has not been resolved because it is very clearly WhatsApp and Signal's policy that we cannot. And I mean, I actually believe that they cannot technically break end-to-end encryption. So how does the government get around it? They don't go to WhatsApp; they just go and seize your phone. So how? And then if you've deleted messages, then that gets used against you. Oh, you were using Signal with disappearing messages. Of course, you had something to hide. So I mean, you're kind of doomed if you use it. You're doomed if you don't. So that's how. I mean, I don't think there's been a resolution where, like the Apple FBI case, where Apple just said we will not break the iPhone encryption. Like, we are not going to do it. That has not happened to my knowledge, and I mean, subject to correction from both of you, in a specific case. The workaround is just much easier. You go to the journalist or the accused directly and take their phone.
Yeah, that's scary. I mean, that came up in the first session as well about seizure of devices, but we won't go into that right now. Shreya, I want to ask you, Justice Sundaresh of the Supreme Court had earlier this year delivered a lecture. It was titled State Surveillance and Privacy, the Lakshman Rekha Between. In that, he actually said that, and I quote, there must be a codified law that empowers the agency to undertake acts of surveillance. Such a law must be subject to constitutional mandate. It will prevent arbitrary action, preserving the privacy of individuals. Given that now they're trying to codify this law and give it a constitutional mandate, what chance do citizens have to then say that, hey, you're invading my private space, despite there being a 9-judge ruling that privacy is a fundamental right?
So I think to understand that, let's see what all information the government may be able to get with just your use of a telecommunication service, which is just making a call or sending a normal text message. Forget what is internet based for a minute. You come directly to your tower location and CDR, which means that they can get pinpoint location to where the tower is located of your location. It's not so MI5 that they can track you with GPS on this service, but you can get to a tower proximity, you get your location, which means that they are able to, within that tower proximity or that radius of say 1 kilometer, if they have their suspect also there, they'll say, yes, this is good enough. You are both in the same tower. You are both talking to each other. They'll know who you are talking to, how long you are talking to that number, and then that web begins. So that is one crucial information. Already, when you go to the Airtel store or the Vodafone store, Jio or whatever, you have to give your Aadhaar card. You had to do that re-verification to get it. So your service provider has your Aadhaar details. By having your Aadhaar number, it is easy enough to get for the government to get out your biometrics. With your Aadhaar number, you can get your PAN, you can get any other account linked to that, you can get Paytm, you can get all of your web-based and internet-based applications and information. This is what you can get from a single phone number. Now, if you are looking at what the bill states, the bill allows for them to come to you, of course, for seizure and search, and to ask you and interrogate you basis other things, because this whole act, this whole bill is without prejudice to any liability. And I find it very funny that they would use without prejudice to any liability of any other act in force at the time. So it's without prejudice to anything else they may want to put on you under the IPC, UAPA, any other provision, IT Act, anything, all of that separate. Now, you get this information out. That means your whole life is unraveled before them to be able to pinpoint you with some crime. How do you protect that? Are you going to criminalize using a phone? Because some of the penalties is to suspend use of telecommunication services. So you may be jailed for 1 year for whatever crime you may have committed, but coincidentally, it also infringed and was a crime of the Telecommunications Bill. So one of your penalties may also be no use of phone.
Yeah, that's. I mean,
So your fundamental rights at every stage. It's not just privacy, it's how much information that you unwittingly, just by your presence, fleeting or not, are is contained in a phone, which has become so fundamental. So
that's right. It's become like a one strike you're out rule. I was just about to do that. There's just one last point that I'd like Apar to make before we go into the questions for the audience. We've spoken a lot about what the provisions of the act are, what how onerous they are. As far as users are concerned, what are the user duties? What are the penalties that users might face if they contravene the act?
So the user duties are essentially whenever you use a telecommunication service, you have to provide your full particulars and not to use any misleading information, which essentially also ties in with the biometric authentication, which is necessary verifiably. And the second provision under that is and provide any other information as may be required under this act, which is vague drafting, which is a hallmark of the recent laws which govern digital communications largely.
And what are the penalties if one were to contravene?
As per the schedule, the first penalty is 25,000 rupees and a continuing penalty thereafter of 50,000 up to 50,000 rupees per day.
Yeah, I mean,
per breach.
Right, right. The Department of Telecom on the 1st of December said that from the 1st of January, there's going to be no more paper KYC. They're going to now.
Yes, there were not going to be any ATMs in India as well, as per Mr. Amitabh Kant 2 years back.
Yeah. Okay, thank you all for a wonderful discussion. Let's open the panel to audience questions now. Please, in the front row.
Is there is there a Supreme Court? I don't know whether it's an order or an advisory that mobile connections cannot be linked to your verifiable biometric identification.
Why don't you get that? Okay, yeah. Can we have one or two questions together so that the panelists can then answer them?
So none of these laws give any special provisions for journalists, but I'd like to know from the panel that what are the difficulties you perceive that the journalists will face after these become the law.
Good evening, sir. This is Utkarsh Mishra. Actually, we had an insightful discussion on this and we delved deep into the laws. Can we have any method to appeal against these laws in a court of law? Like, can we have another Anuradha Bhasin judgment of Shreya Singhal versus Union of India?
Yeah, so apart the three questions, if I can just recap quickly, are we'll start. Okay, sure, sure. So no, that's fine. Just to recap, do telephone connections need to be linked to biometrics and other personal information? Are there any specific safeguards for journalists? And can we have any other protection from the courts?
So I'll take the second one, if you don't mind, which is there does and specifically with this, does this deal with any special rights to journalists? There is one which is in section 20 section 3, which says that correspondence accredited to the central government or state government shall not be intercepted or detained, communication from them shall not be intercepted or detained unless the transmission has been prohibited for national security. Yeah. So, in essence, there is, unfortunately, the press is and journalists are the ones who are targeted first because they are the points of dissemination of information. So if you stop the source, go to the source, stop the source, then automatically you have stopped the dissemination of information. What people then get is a series of misinformation, which is what they are hoping to thrive on, to then use that as an excuse to cut communication.
Yeah, so I think maybe you're talking about the Aadhaar judgment where there was a order of the government mandating that Aadhaar verification for your SIM card. So that was struck down by the Supreme Court, saying that that was disproportionate. It couldn't be done in the garb of an executive circular. So I think maybe that's what you were talking about, and that was struck down. On what you can do, I mean, I think the only thing is challenge it in court, or support organizations like IFF who do challenge it in court, because there is a real funding issue, which so I think it would really help all of us, and we could do our work better. I think if we get the support from all of you.
So just to be clear, I'm not in any capacity representing IFF. I draw no financial benefits whatsoever. I have not done since March. First things, with respect to classification of press messages under section 20, subsection 3 of this proposal, I don't think so it provides any benefit, because the subcategorization of correspondence accredited with the central government reverts back to the same power under section 20, subsection 2, subsection A. So what it means is that your messages can't be intercepted except when there is an order, but that order would anyways be there, right? And secondly, this section does not override other interception powers which are there. For instance, criminal processes under what may be the new CRPC, right? Okay. The second thing was, coming back to Ritu's question, the basis of the Aadhaar mandatory link to mobiles was a PIL which was filed by Lokniti, which is not Lokniti CSDS, but was another NGO called Lokniti, right? And an order was passed in that, in which the Supreme Court said, yeah, because the government also came and said, yeah, we can link Aadhaar with telephone connection. So, yeah, let us do it. So the court said, yeah, go ahead, do it. The petitioner is saying, the Sarkar is saying that we can do it. Petitioner is saying, do it. So let's do it. But the government then made it mandatory. And in the in the Sikri judgment, 5-judge bench judgment, not the 9-bench right to privacy judgment, they struck it down as unconstitutional, because the government, the order of the court, which was cited in support, was saying you can do it as one of the methods of authentication, but the government made it mandatory. So that is what was struck down. But today, the flow itself by most telecom service providers is that you get it cheaper and quicker, okay, because of regulatory design and also increased data capture if you do it through Aadhaar, right? And what that is also happening is that each telecom service provider is also a content provider, is also a financial lender. Okay, so you have to understand that in the larger basis of how large corporates are now emerging in India, which will be only 5 corporate groups in India, right? They need our data. And the third and the final thing is that, can you get judgments like Anuradha Bhasin and Shreya Singhal? You can, of course, get judgments like Anuradha Bhasin, because that's a lecture. The court did not even judicially examine one shutdown order. It only laid out guidelines and sent it back to the government to examine. And then 3 petitions were filed. The Anuradha Bhasin judgment did not result in the restoration of access. In fact, my friends joke, it was a tweet by Rihanna which got internet restored in Jammu and Kashmir. Okay? Now, can you get judgments like Shreya Singhal? And I say this with respect, for I say this, actually, I tweeted about this, and I'm quite glad Justice Nariman also said it in his lecture. In Shreya Singhal, he refused the assurances by the additional Solicitor General at that point in time that this law is bad, it's vague, and it's being abused, but we'll use it in a way which will be much better. But what has happened in the Article 370 judgment shows that how far the court has shifted. So you will get judgments like Anuradha Bhasin. You will get the best of times and the worst of times, and quotations by brilliant authors, works of literature, but you will not get judgment. You will not get an enforcement of constitutional rights. And hence, Section 66A would be unconstitutional today. It won't be struck down. This is the sad truth.
You're very sad indeed. Can we have some more? Yeah.
Sorry, just to add to what Apar said, it's the Privy Council, a judgment of the Privy Council that said once you get a decree, the real struggle for a litigant is the execution. And all of these constitutional judgments dealing on specifically and very importantly dealing with constitutional issues, there is no enforcement. It's a moot point.
We'll have one more round of questions.
Yeah, hi.
Yes,
I'm
please.
So my first question is about the authentication slash licensing that is there. How will they implement this? Like, are there any thoughts on that? Like, is it completely dependent on the telecom network to sort of make the users give it to them, or how will they implement this? The second is about this intelligible format word that they've used. Just want to understand how far they can take it. Essentially, is it only about decryption, or will they make you give evidence in a format that they wanted? What is this exactly?
So yeah, these rules and regulations are still to be prescribed. All of them say as prescribed. So we're still waiting for the rules and regulations to come out. But Vrinda, why don't you give that a shot? The first half of his question.
No, I mean, I think it's that right now we don't, because it will all come out in rules. And how far they'll go, honestly, is just a matter of like how much they're willing to try and like what gets challenged. So I think at this stage, I wouldn't have any expectation of what is going to happen or, how much, because it does say, so for instance, if a person is intending to provide telecommunication services, they shall obtain the authorization from the government subject to such terms and conditions, including fees or charges. So now, whether these terms and conditions will be given to individual telecommunication operators as they're providing, whether the government is going to notify a general set of rules, is it going to be like the uplinking, downlinking guidelines, which have also been pretty controversial recently? So, I mean, it all depends. I mean, I think there's just a complete lack of clarity. And that's what you see, right? Like now there's this whole tendency of delegating everything without any legislative guidance. So, yeah.
So yeah, I guess thank you all for a wonderful discussion. What seems to come out from it is that despite the new laws meant to be future ready and taking us into a age of digital expansion, there seems to be more gray areas being created than answers actually being given. I thank all the panelists for a very engaging discussion. Thank you. You've been a wonderful audience.